In terms of claims against police officers or police departments for excessive force, there's always going to be an analysis of what force was necessary in order to subdue or restrain the person being arrested. Sometimes you have situations where an officer in a given particular matter might have viewed it as more dangerous from his personal or her personal subjective viewpoint. And the question becomes, what's reasonable? The question of what's reasonable, as you can imagine in everyday life, is always a gray area. There are cases which interpret force being used in one sense or another as reasonable, and then in the very similar fact pattern, a court may find that that same level of force given the particular arrestee is not reasonable. Certainly in excessive force cases, most oftentimes the successful claims are ones where there are significant injuries. If you suffered significant injuries in connection with an arrest or some type of law enforcement confinement, you certainly would want to seek the advice of an attorney and do so quickly, because there are very short statutes of limitations under which you can bring these kinds of claims. Oftentimes clients are unaware that even though you may have a year to sue under state law, or in New York 3 years to sue under federal law, there oftentimes are notice of claim provisions that need to be filed within something as short as 30, usually 30, sometimes 90 days, depending on what municipality or district you're going against. And those types of things cannot be waived. Statute of limitations are really critical in terms of analysis of whether you have a viable claim. And then, of course, you have to get into the facts of whether the force was used in an excessive way, in a reasonable way, in a way that other police officers would agree or disagree with.